So I believe, Your Honor, that...
well, that's not what the statute said. The statute says that you have a two-step process. You have to go through a change of circumstances, and you must show best interest. That's why some have reviewed that first section, A, as being the more strenuous standard because it calls for a determination of both.
Yes, Your Honor, and I believe that if the court were to modify the entire shared parenting plan, that subsection A is the standard to apply. But if the court is going to modify a term of the plan, in this case, we submit that the residential parent status is a term, then subsection B would apply. We think that the statutes obviously must be read together to give it the legislative intent that was given by the legislature at the time. To accept the appellant's arguments that for the court to modify the residential status and nothing else fits under subsection A, but all other terms fit under subsection B, ignores the plain language of the statute, asks the court to separate these two statutes, not read them in pari materia, to ignore the first sentence of E2, which states that in addition to what is set forth in A1, and to determine that somehow custody is not a term.
Well, I have one last question. If the father and the mother in a shared parenting plan have 50% rights,
yes, Your Honor,
in terms of time, possession and time of the child, and the mother is now designated not for purposes of environment or for moving, but is designated the residential parent, similar in this case.
yes, Your Honor.
Could the mother then forbid the father from having more than 50% of the time?
If the court order specifically said the father had 50% of the time, I think she could, yes, Your Honor. I think that, the father's rights are both parents' rights grow out of the decree at that point in time, and reference would have to be made to the decree as to what's
So why wouldn't the allocation of rights have changed?
I believe it has changed, Your Honor.
Oh, okay.
As to the rights, as to determination. Now, when you look at what Judge Zitter did in this case, she did not change the parents' rights specifically in this case as to time. I think she tweaked a little bit, but did not really change it. So she's changed the rights.
But you do believe that under the present order, that the mother could control the time that the father would have with the child, even though under the order it says 50%?
No, Your Honor. The order specifically says that the father has certain days, I believe it was Tuesdays and Thursdays from 7 in the morning for a 24-hour period, and every other weekend from Friday at 7 to Monday at 7. So the times and dates were set forth. Mother cannot change that. She would be in violation of the court order, and that it would not be permitted.
In your view, did the trial court terminate the shared parenting or modify it?
She modified it, Your Honor. The trial court modified it, Your Honor, in my opinion.
And it's the finding of the Court of Appeals that it was modified
that is
in
correct.
that respect.
Yes.
All right. Thank you.
Your Honors, the appellant submits that if the court were to rule that the standard under subsection B were accepted, that this would increase litigation and lead to harm to children. First, I realize judicial economy, we want to cut down on litigation, but I think the standard that all of us, the courts, the attorneys, the parents must look to is what's in the best interest of the children. I can't see how a court saying this is what is in best interest of the child is going to harm a child. When an argument's made that somehow saying the standard is do what's best for the child, judge, make the best decision for this child, I can't see how a court could say that somehow is going to harm that child. Also, Your Honor, when it comes to the issue of constitutionality, as I set forth in my brief, the burden is upon the appellant, since he's raising the constitutionality issue, to prove beyond a reasonable doubt that the statute is unconstitutional. They have submitted no proof, no evidence as to anything as to unconstitutionality other than just what I call their unfounded speculation as how this will affect future cases. The statute is not void. It's very specific. If you want to terminate a plan or modify a plan, here's the way you do it. But under subsection B, the court also can look to what is in the best interest of this child in terminating or modifying a term of that. And I don't see that the term residential parent is any different than any other term. If the court says, I'm going to designate who takes the children to school, that's a term. If the court says, I'm going to designate who will make the medical decisions, that's a term. If the court's going to say, I will designate who's going to give haircuts, that's a term. If the court's going to say, here is who has residential parent status, that's a term. I don't understand the difference here, and I don't believe the court does either. If there are no further questions, Your Honors.
Thank you, Mr. Tesno.
Thank you, Your Honors.